Welcome back to the High Court Report. Today we break down an asylum authority showdown involving court deference to fears of cartel violence. This case, Urias-Orellana versus Bondi, could reshape how federal courts review asylum decisions. The court scheduled oral arguments for Monday, December 1st.
This case cuts right to the heart of something really fundamental. When should courts trust government agencies, and when should they make their own independent decisions? We've actually seen the court grapple with this exact question recently in other contexts. Just this term, during oral arguments in Fernandez versus United States and Rutherford versus United States, the justices wrestled with how much deference courts should give to the Sentencing Commission's interpretations in the criminal law context.
That's such a great point. This whole question about agency deference has been percolating through different areas of law ever since the court's landmark 2024 decision in Loper-Bright Enterprises versus Raimondo, which completely overturned the Chevron deference doctrine.
Exactly. Now, this case involves life-or-death stakes. The family here fled cartel violence in El Salvador, but the government said their experiences don't rise to the level of persecution under U.S. law. The question is, who gets to make that call? So for our listeners, here's what makes this case so important. Right now, different federal courts apply completely different standards when reviewing asylum cases. Some courts defer to immigration officials, while others conduct their own independent review. This creates a patchwork system where a person's chances of winning asylum might depend on which court hears their case.
That's a ticking time bomb waiting to explode. The Supreme Court granted certiorari to resolve this mess, and their decision will affect hundreds of thousands of asylum cases every year. Let me read you the exact question the court will decide: whether a federal court of appeals must defer to the BIA's determination that a given set of undisputed facts does not demonstrate mistreatment severe enough to constitute persecution under 8 U.S.C. Section 1101 of 42.
Now that might sound technical, but let me break down what that really means. The Immigration and Nationality Act defines a refugee as someone with a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. And here's the key. The law says non-citizens hold presumptively eligibility for asylum if they suffered persecution in the past. But it doesn't define what persecution means.
Right. So the question becomes, when a family like the Urias-Orellanas presents undisputed facts about cartel threats and violence, who decides whether those facts legally qualify as persecution, the Board of Immigration Appeals, or federal judges?
That's fascinating because it cuts to the tension between factual determinations and legal interpretations. The statute clearly gives immigration officials the job of finding facts, like, did this happen? Or is this person credible? But applying the legal definition of persecution to those facts, that's where the fight is.
This gets even more interesting when you look at the review standards the statute actually sets up. The Immigration and Nationality Act creates what petitioners call a reticulated scheme, basically a detailed framework for when courts should defer to immigration officials.
The statute says courts must accept agency findings of fact if they're supported by substantial evidence. It also requires deference on questions about whether someone is eligible for admission and on ultimate discretionary decisions about granting asylum, but it's silent on persecution determinations.
Let's talk about the human story behind this legal dispute. The Urias-Orellana family, Douglas, his wife Syra, and their minor child lived through what sounds like a nightmare in El Salvador. A cartel hitman called a sicario targeted their extended family in a years-long violent vendetta. This wasn't random crime. The sicario shot 2 of Douglas's half-brothers while explicitly threatening to kill their relatives. And then armed cartel members repeatedly threatened and physically attacked Douglas himself. They pursued his family across El Salvador for several years. Eventually, the family fled to the United States and requested asylum.
Now, here's where the legal process kicks in. An immigration judge denied their asylum claims. The family appealed to the Board of Immigration Appeals, which upheld the denial. The BIA concluded that the death threats and physical assault Douglas experienced did not constitute persecution.
Wait, so you're telling me that being shot at by cartel members, receiving death threats, and being physically attacked over several years doesn't count as persecution?
That's exactly what the BIA said. They wanted evidence showing significant actual suffering, like documentation from a physician or psychiatrist. Without medical records proving psychological trauma, they said it wasn't persecution. The family then appealed to the First Circuit Court of Appeals, which is where this case really gets interesting from a legal perspective. The First Circuit refused to exercise its own independent judgment about whether these facts constituted persecution.
Instead, the court applied what's called substantial evidence review. Basically, they asked, did the BIA reasonably conclude that these facts don't constitute persecution? They didn't ask, do these facts actually constitute persecution?
That's a huge difference. Under substantial evidence review, the court acts more like a referee checking whether the BIA followed proper procedures, rather than making an independent decision about what the law requires.
The First Circuit upheld the BIA's decision, and the Supreme Court granted certiorari to resolve what's become a deep circuit split on this issue.
The Supreme Court granted certiorari because federal courts across the country handle these cases completely differently, creating the exact kind of legal uncertainty that the Supreme Court exists to resolve.
Let's dive into how each side makes their case. The Urias-Orellana family makes three main arguments, and their first one is really centers on constitutional roles. They argue that deciding what legally qualifies as persecution constitutes fundamentally a judicial function. They quote Marbury versus Madison. It is emphatically the province and duty of the judicial department to say what the law is. Their point is that Congress gave immigration officials the job of finding facts, but interpreting legal standards, that's what courts do, and they point out that the Immigration and Nationality Act doesn't actually authorize deference on persecution determinations.
That's really important because, as we already mentioned, it ties into recent Supreme Court jurisprudence. The petitioners invoke Loper-Bright Enterprises versus Raimondo, which we covered earlier this term.
Right. The petitioners argue that substantial evidence review is just Chevron deference under an alias.
Their second major argument gets into the nuts and bolts of how this review actually works. They claim that when courts apply substantial evidence review to persecution determinations, they're essentially asking, did the BIA reasonably interpret what persecution means? But under Loper-Bright, that's exactly the wrong question. Courts should ask, what does persecution actually mean? If the BIA's interpretation isn't the best reading of the statute, then it's not permissible, regardless of whether it's reasonable.
The petitioners also point out something really interesting about the BIA's own regulations. The board itself treats persistence determinations as legal questions subject to de novo review when they're reviewing immigration judge decisions.
Wait, so you're telling me that the BIA reviews these same questions without deference when they come from immigration judges, but then demands deference when federal courts review the BIA?
Exactly. The petitioners call this certainly odd, to say the least. If the BIA itself concludes these are legal determinations, why should federal courts treat them as factual findings?
The petitioner's third argument focuses on what lawyers call the mixed question analysis. When you have a legal standard applied to specific facts, courts ask whether the determination is primarily legal or primarily factual. The petitioners argue that persecution determinations are primarily legal because they require courts to elaborate on the broad legal standard and develop auxiliary principles of use in other cases.
For example, courts have established that economic hardship alone doesn't constitute persecution, and that mere harassment or discrimination also falls short. These legal rules provide guidance for future cases, which is exactly the kind of legal work appellate courts should do. Now let's look at how the government responds, because they see this case completely differently. Attorney General Bondi's office makes three main counter-arguments.
In their opening salvo, they reframe what this case actually centers on. They argue that persecution determinations represent predominantly factual questions that fall squarely within the Immigration and Nationality Act's substantial evidence standard. The government heavily relies on the Supreme Court's decision in Ming Dai versus Garland, which they say recognize that questions about whether an applicant was persecuted in the past or fears persecution in the future are predominantly questions of fact.
But here's where things get interesting. The government argues that these aren't pure questions of legal interpretation. Instead, they involve fact-intensive work of inferring and weighing a multitude of facts, including conditions and political situations in foreign countries. They point out that immigration courts make over 200,000 asylum decisions annually, with more than 2 million requests still pending. The government argues that this massive volume demonstrates why these questions require agency expertise rather than legal development by appellate courts.
The government's second major argument tackles the mixed question analysis head-on. They contend that under U.S. Bank versus Village at Lakeridge, persecution determinations involve primarily factual work. Specifically, they argue that these decisions require marshaling and weighing evidence and making credibility judgments, rather than developing legal principles. When a case involves primarily factual work, the deferential standard applies. The government also makes this practical point. In most asylum cases, immigration officials just apply settled legal standards to varied facts. They're not creating new law. They're doing the fact-intensive work of determining whether specific circumstances meet established legal criteria.
Their third argument directly confronts the petitioner's Loper-Bright claims. The government argues that the petitioners fundamentally misunderstand what Loper-Bright actually decided. The government says Loper-Bright addressed agency interpretations of the statutes those agencies administer. Pure legal questions about what statutes mean, but this case involves fact-bound applications of law to facts, not pure legal interpretation. They point out that Loper-Bright itself acknowledged that courts have applied deferential review where application of a statutory term was sufficiently intertwined with the agency's fact-finding to make it fact-bound. So the government's position is basically Loper-Bright doesn't prohibit substantial evidence review of fact-intensive mixed questions. Persecution determinations are predominantly factual, and the Immigration and Nationality Act clearly requires substantial evidence review here.
Looking ahead to oral arguments, there are several key tensions I'll be watching for. First, I'm really curious how the justices react to the practical examples both sides raise when petitioners talk about the BIA demanding medical documentation for psychological trauma, or the government talks about the volume of asylum cases. Do the justices seem convinced by these practical concerns?
I'll also be listening for questions about Loper-Bright's scope. Do the justices think Loper-Bright resolved this issue in the petitioner's favor, or do they see room for the kind of factual deference the government advocates?
The federalism angle could be interesting too. Immigration law is federal, but the practical administration involves both federal agencies and federal courts. Does this court see persecution determinations as an area where agency expertise should predominate?
Plus, given this court's emphasis on text and statutory interpretation, it'll be fascinating to see how they analyze Section 1252's structure. Does the statute's silence on persecution determinations suggest Congress wanted de novo review, or does it suggest these questions fall within the substantial evidence standard? I'm also curious whether any justices press the government on the BIA's own treatment of these questions. If the BIA itself treats persecution determinations as legal when reviewing immigration judge decisions, how does the government square that with demanding factual deference from federal courts?
And there's this interesting institutional question lurking beneath the surface. Should Article 3 courts or administrative agencies have the primary role in developing asylum law? Different justices might have very different intuitions about that.
This case perfectly illustrates how seemingly technical questions about standards of review can have enormous real-world consequences.
Absolutely. If the court sides with the petitioners, it could lead to more uniform asylum law development and potentially more successful asylum claims. Federal courts would exercise independent judgment about what constitutes persecution.
But if the court sides with the government, it would reinforce agency expertise in immigration law and potentially create more deferential review of asylum denials. The practical effect might be fewer successful appeals, of negative asylum decisions.
What's really striking is how this case sits at the intersection of so many important legal developments: the death of Chevron deference, debates about agency expertise versus judicial review, and the ongoing crisis in immigration courts. The stakes extend far beyond this individual family, even though their story is heartbreaking. We're talking about the framework that will govern hundreds of thousands of asylum cases for years to come. And remember, asylum law directly implements America's commitment to international refugee protection. How we interpret persecution affects whether the United States fulfills its obligations under international law.
We'll definitely cover oral arguments on December 1st, and we'll break down the eventual decision. This is exactly the kind of case that could reshape an entire area of federal law.
Thanks for joining us for this deep dive into Urias-Orellana versus Bondi. It's a powerful reminder that constitutional principles and statutory interpretation have direct, life-changing consequences for real people.
As always, if you found this helpful, please rate and share the podcast. And if you're an immigration attorney, federal judge, or work in this area, we'd love to hear your thoughts on how this plays out in practice. In our next episode, dissect an immigration law case called First Choice Women's Resource versus Platkin. In this case, the Supreme Court must answer whether federal courts can hear First Amendment challenges to state subpoenas immediately, or whether challengers must first litigate their constitutional claims in state court. We'll break down this heated case for you. Thanks for listening to the High Court Report. If you enjoyed the content, please follow, rate, and share the podcast. Also, we always welcome fan engagement. So, follow our LinkedIn page or shoot us an email if you have any questions or comments. Talk to you soon.